Okay, should I?
Yeah,
I will
let's go on.
leave.
Could
Yeah.
you could you check if the stream is showing up on your feeds?
Yeah, one sec.
Yeah, we'll check.
Okay, so I got on the Facebook, I got on my YouTube. Yeah, so we
It
are
says 7 p.m., right? Live in 4 minutes.
okay.
Okay, one sec. Yeah, it's live. Yeah.
It's live on YouTube. Okay, that's fantastic. And so let me also start the webinar so people can start coming in. Is Vicky going to be here continuously, or should I?
No, you can remove us. Yeah, you can
Okay,
remove.
okay,
Okay,
fantastic.
thank you. Good luck, guys.
All right, thank you.
It's always a bit of a challenge, even when you're doing a bigger event like this, and the stream is going to multiple places to get all the logistics right.
Understood. Yeah, I can only imagine.
Where are you based out of?
Northern Virginia, 2 hours south of Washington, D.C.
Northern Virginia, Ashburn area?
I've got a cousin that lives in Ashburn. We're in Culpeper, which is about an hour away from Fredericksburg, kind of in the middle of nowhere, but
Okay,
yeah.
all right. So enabled the attendee to do Q&A. Yeah, participants should be joining in. So we'll start at 7. We still got about 3 more minutes to go.
Okay. Sounds good. Yeah, actually, the little town I live in is called Boston. So usually people are like, "Oh, I've never heard of a Boston, Virginia." I say, "Yeah, that's because there's only 100 families that live here, but or something."
Okay, so we have Washington in North Carolina.
Uh,
So I got invited for a wedding once, and then they said Washington. I was like, "Did you get the state right or wrong?" So yeah, I was surprised to hear we had a small town.
yeah, that's funny.
How long were you with USCIS?
So 7 years. I started in 2012 and left in 2019. So I was there during the first Trump administration or parts of it, and yeah, it was interesting at that time. I remember there were officers that even without any directives, they started saying, "Okay, now we're tightening things up now." And I said, "Well, who gave you that directive? I haven't heard anything." So it's an interesting world. Um, when a new president comes in, there's quite a lot of changes.
Okay,
And this, by far, these are the biggest change. I mean, the past 9 months have just been rapid fire.
okay. Lot of changes in fast pace.
Yes, that's right.
And you become an immigration attorney, or did you have a law degree before USCIS, or did you go to law school?
Yes. So actually, I was planning to go into music. It wasn't until I served as a missionary in South Texas that kind of got me thinking more in terms of doing a career in humanitarian work or something similar. And then when I started law school, I found a mentor in immigration law, and she taught me everything in immigration related to get me along the way with a good foundation. And just one thing led to another. And, um, I've spent time working in practices, family-based, employment-based immigration law practices, and for the government, I had my own law practice for a while, and now with Manifest. It's
Okay,
been,
fantastic.
yeah, it's been excellent.
Good job.
Um, so I've kind of done a little bit of everything. I adjudicated refugee petitions for a time in Kenya when I worked for the government. So
Wow. Okay.
yeah, it's quite a variety. So yeah, been on both ends of the spectrum, but
Okay.
both
Fantastic.
cases, yeah, they're fascinating case types.
Okay. All right. So attendees who are listening to us in live Zoom, we are just having a quick chit chat before we go into the session. I know it's just 7 p.m. We'll just give another minute for everybody to join because people were planning to join at 7. So we just went live a few minutes earlier to get all the logistics of our setup up and working. So today, my guest is attorney Ivan Law, and he is part of Manifest Law. And this webinar is sponsored by Manifest, and we are going to have a conversation about the recent 100K H-1B visa fee, where things have been changing a lot in the past 48 hours or so. So we are doing this live so that we can answer as many questions as possible, so that we can help alleviate some of the uncertainties that the attendees and who are listening is going to have and go through this. All right, I think we can get going, Ivan.
Okay, sounds great.
Hello, everyone. Thank you for joining us. I have attorney Ivan Law from Manifest Law. In this live webinar, which is sponsored by Manifest Law, we will be going over what is this new H-1B 100K fees? Who does it apply to? Who does not apply to? And what does it mean? It applies to all new petitions, which was listed on the USCIS FAQs that was published yesterday. So Attorney Law is here to talk to us about the current knowns and unknowns. Hello, Ivan. Welcome to the live webinar. How are you doing today?
Hi, Raghu. It's great to be with you. I'm doing very well. We're I think a little bit more, a little bit more at ease now that we know a bit more about this program, but I understand there's still a lot of people worried about what this means for the future.
Absolutely. All right. So tell us a little bit more about your background and who you are, and how did you get into Manifest Law and working with them?
Sounds good. Yes. So my name is Evan Law. I've worked in the immigration field for over 17 years, both with firms focusing on family-based as well as employment-based immigration petitions. I worked for the USCIS Administrative Appeals Office for 7 years. And in that position, I adjudicated cases that were denied on the employment visas for EB2, EB3, and EB1As. Those are the extraordinary ability petitions. The EB2s are cases for people that have an advanced degree. And also, when I was at the AAO, that's when matter of Danosaur came out, which is the framework for the national interest waiver cases. So I really enjoyed my time working with the AAO, but ultimately I went out on my own, had my own law practice for a time, then merged that into a local law firm. And then from there, I connected with Manifest, and I've really loved being with them.
Okay, all right, fantastic. Thanks for the intro about you.
Sure.
Let's talk about what is the new H-1B visa fees and what was announced on Friday, what happened on Saturday, and where do we stand as of Monday? So
Okay.
could you give a quick rundown of the summary?
Sure. So President Trump announced that there is a fee of $100,000 that's required for H-1B petitions. Initially, there was a lot of concern that this meant that even people who were overseas wouldn't be able to return until they paid the fee. There were a lot of questions that attorneys had, and that people potentially affected by this had. But now the government has come out and clarified that people who already have an H-1B, who are in the US, or if they're abroad, they can come back in. So in other words, the new fee or the fee only applies to new petitions that are filed after September 21st of this year.
Okay. So when the fee applies to only those petitions are filed after September 21st, does that mean if somebody is going for a visa stamping for the very first time, the H-1B has already been approved, but they have never had stamping before, will they have this fee?
They will not have to pay the fee. So the petition has already been approved. They're able to travel overseas, get the visa stamping completed as needed, and then they're able to return.
Okay, all right. Second scenario, applying for H-1B extension after 3 years have expired or 6 years have expired, or they have an I-140, do they have to pay 100K fees?
They don't have to pay the fee as long as they stay with the same employer. What we don't know is what's going to happen as far as if people want to change employers. Right now, that the interpretation that our firm is taking, and that I think a lot of attorneys are taking, is that does require a new petition being filed, and so the $100,000 fee would apply in that scenario. We do want to let people know that we need to keep monitoring this and to see what those interpretations are. One of the biggest challenges now is that the FAQ that the government put out says that renewals will not be affected, but they haven't defined what a renewal is. And so, and the most conservative approach to this is that, in recognizing that most likely it's the petitions that are filed for entity, petitions with the same employer.
Okay, so still that piece is uncertain. If it's a new employer, which will also apply to my next question, if it's an H-1B transfer process from employer A to employer B, that fee could apply or it may not apply, and we do not know that yet.
Right now, we're still waiting for guidance on that, but right now, the viewpoint of our firm is that the fee would apply in that scenario.
Okay.
And so there are still a lot of unknowns with this. A lot of people are asking what happens if we change from one visa to another, or what happens if we change from one employer to another. In both of those scenarios, it's likely that the fee does apply.
Okay. And what about change of status to H-1B? Somebody had previously H-1B, they went to H-4, or they went to B-1, B-2, now they are transferring into H-1 again. In that, two possibilities, to a brand new employer or going back to the previous employer whose H-1 was approved earlier.
Well, it's a great question, and a lot of these things are going to become more clear as time moves on. But the guidance, that we're seeing now is most likely they would have to pay the fee as well. Yeah, even though they were with the same employer before, it's still a new petition that's being filed to request an H-1B status.
Okay.
So those are the types of things that immigration attorneys are going to look at and say, listen, this doesn't make sense. Like, why we would be penalizing these people where they had an employer before, they had the petition before, but at the same time, it is a new petition that needs filed. And so our understanding right now, until we receive further guidance, is that yes, those people would have to pay the fee. But when I say those people, I mean the employee.
Okay. Could you define a new petition? Is transfer a new petition, or is changing to another employer a new petition, or amendment is considered a new petition, or the first time? So what qualifies as a new petition?
Well, and that's a great question. The very basic answer to that is, you're filling out a new I-129, and that's what's being filed. So that would constitute a new petition. In other words, the term extension is basically at that point you are filing the I-129 to extend your status. But that most clearly falls within the term the USCIS has used, which is renewal, where they're renewing the same petition that for the same employer. Those people will not have to pay this. But when you're talking about, like in your scenario you brought up about a person who had the H-1B, then went to H-4, and then they're going back to H-1B, there really isn't a really clear way to say that is a renewal. You can't be renewing something that you had changed from before. And so that's why our view is that these types of either changes of employer or change of status from another visa type, that those will be ones that require the fee.
Okay, all right. And for listeners who just joined after we started, this webinar is sponsored by Manifest Law. I'll be sharing the link on the chat in at least in the Zoom that we're doing right now, for the listeners, if you want to talk with attorney, even or another qualified attorney from Manifest Law, you'll be able to schedule a consulting call. Use the unique URL that I'm going to provide, mention Happy Schools, to get the consulting, so that I know a lot of you have a lot of questions. If you have any specific questions that applies to your scenario that we're unable to answer in this call, you should consider scheduling a consulting call with them. And Ivan, would you be okay if we take few questions where somebody from this call speaks to us and asks the
Yes.
question? Okay. All right. So
Yes,
that's fine.
attendees, if you want to raise your hand before even I ask, there's a person here. So Payush, what's your question? Please keep it to brief and to one question, please.
Can you hear me?
Yes.
Okay, so scenario is the H-1B with I-140 approved, been in the States for 10 years. And then let's say, and the employer is same all the time, and you leave, you go to India. You work from India, let's say for the same employer for a couple of years. Now you want to come back to the States on, let's say, H-1B. Obviously, you have other possibilities as well, L-1. But let's say if you decide to come back on H-1B, is it considered a new petition because you already have been part of the lottery, so that you are cap exempt? However, now because you left your H-1B, went to India, now after a couple of years, you want to come back to the same employer.
Wow, that is an excellent question. And so let me ask you this. So before you left, how many years were you on the H-1B, or the person you
So 2014 to 2025, like 11 years with all extensions. Yeah, there have been like 3
Okay.
extensions pretty much.
Okay. And so in essence, you've been extending on that 7th year, just waiting for a priority date to become current?
Priority date is 2016, let's say. Yep, that's right.
Mhm. Okay.
So in this
Well,
case, the only thing is employer hasn't changed and your visa also hasn't changed from a US perspective. You always been on H-1B, but then
Mhm.
again, you want to come back on H-1B. There is no interim change of like H-1 to B-1 or anything like that. That hasn't happened.
That's a very interesting scenario. So let's talk about this in 2 different ways. Let's talk about one way of thinking about this is if somebody is here in the US and they have the H-1B where they've been extending that 7th year just indefinitely, waiting for the priority date to become current. Well, every time they do that, they are renewing their H-1B petition.
Correct.
And so the question is then when if that person leaves the United States, I mean, if they leave and go abroad, they could return at any point still on that H-1B visa, right? So in my view, this is a kind of, I mean, quite an interesting scenario, but it seems to me that would not require the new fee to be paid. So I guess the challenge with these questions, you don't need to tell us who this relates to, but I think a key question would be, from the attorney's perspective, is just trying to understand, well, how often has that person come back into the US?
Yeah, so you've been in US actually all the time.
So I think probably another extension of the question, Ivan, is
Mhm.
it goes back, but the H-1B expires and the company have to refile again because the status has been not maintained continuously. Let's say I-94 is expiring 26 January. He leaves this month, but he comes back after 2 years. So with I-140, he should be able to get another 3 years of extension. But will he be subject to 100K fees because it is not a continuous extension?
It's most likely that the $100,000 fee would apply, because when you look at an extension of status or even a change of status, you have to extend the status before it expires. And so if that status expires, then it's most likely would be viewed as a new petition. But I will say this, just in general, when I worked for the government, there were a lot of times when supervisors or managers would get together and they'd say, listen, we haven't seen this issue before. How is it going to play out? And so a lot of this will be evolving over time. But from the guidance we've seen right now, my assessment would be if it expires, that means it's no longer considered an extension. If it's not an extension, it doesn't fit within the term of a renewal. And so most likely the fee would apply.
So real quick, actually, if you don't mind, Raghu, sorry, just 15 more seconds. So in this case, I was talking situation, your even H-1B is still valid. So it's valid till 2026, end of 2026. And even before you want to come back from abroad, I was talking about, because you have been, let's say, out for a few months.
Perfect. Okay.
Yes.
Yeah, so then, becoming before it expires, then there should be no issues with that, because the government has stated anyone on a valid H-1B visa right now can travel in and outside of the United States without any problem, and the fee will not apply. And so,
But the thing is, once you leave US, let's say, right, now you're joining, let's say, employed in India, but it's the same company. It's a subsidiary company, obviously, the India unit. But so once you leave the country, H1, even though it's valid, right, technically, but you are no longer H1. You can come back, let's say, tomorrow, just like that. You can. Because, yeah.
Well, and that is the challenge then, because the tool that they're using is, for new petitions that have been filed. And so this is a really good question.
So, Payush, probably you can take it offline directly with them.
Sure.
I will share the link. I'll go move on to the next question. Okay.
Thank you so much, attorney.
Yeah, sounds
Thank
good.
you.
Yeah, that one I would say it's a good idea to consult with an attorney and take a deep dive in that.
Sure.
Great session. Yeah.
Next question from the Q&A from Netra. Can you please clarify if OPT and STEM OPT students, both CAP subject and CAP exempt, are now part of the new H-1B rule if they move to H-1B with change of status in the next year lottery?
Yeah, so unfortunately, our interpretation is that by doing that change of status, that is a new petition, and so that would require the fee. The proclamation didn't mention anything about OPT. The FAQs have not addressed OPT and things like that. So I would say just to have some patience with this as we see more guidance coming out. But right now, the interpretation that we have is that it would be a new petition and it would require the fee.
Okay. All right. So the next question is, if a candidate who was in H-1B got laid off and now transferred to H-4, now accepting an offer and doing change of status from H-4 to H-1 via premium processing, different employer.
Yes, in that scenario, it's very similar to the things we've been discussing before, that based on the fact that it is a change of status, it would be viewed as a new petition and require the fee. It's a really unfortunate scenario in that case, and I think there can be good arguments to be made as to why that shouldn't be affected that way with the layoff. But this is the way we're interpreting this, is that it would be a new petition. Okay.
So along the similar lines, a question from another person. How does transfer of an employer means new petition in USCIS? Where does the interpretation come about the transfer as a new petition?
Well, the major issue is that they restricted the language to who doesn't have to pay the fee to this term renewal. And so, they didn't use the term extension. There's nowhere on the I-129 that uses the term renewal. So it's unclear whether the government has a different understanding of that, whether they will say under renewals, we are going to view that as change of status or change of employer petitions. But for now, our interpretation is just that this requires a new petition being filed, and so it does require the fee.
Okay, all right. Amrita, what's your question?
My question is actually answered previously by the question that you asked, I think, from the Q&A session. But I just wanted to get the clarity on whether the H-1B fee is going to be for both CAP and non-CAP categories. That part I didn't get.
Yes, they haven't specified one way or the other. And so the fee would apply to both. There is the national interest exemption that we don't know exactly how that will play out, but yes, these are basically just applying to all H-1Bs.
Okay.
And that is basically for all transits, even from F1 or L1 to an H1B.
Yes.
Would
It
you be
changes.
okay? Would you be having any idea about how long would it take for them to answer the technicalities in more detail?
So when I from the government, I generally felt like it did take quite a bit of time for these policies to be fully fleshed out. Certainly, there weren't changes being made to the extent that the Trump administration is doing now when I worked for the government. But you know, the government did, the USCIS did come out very quickly to clarify some things when they saw that, you know, the interpretation you know, of the proclamation, you know, needed some guidance. But with things like this, there are a lot of things that are going to come out when the officers start adjudicating the cases, and then supervisors start realizing, wait a second, how does this apply in this scenario or this when someone has an I-140 approved? Does that make it a different scenario than this other than without? And so it's difficult to say that, but I would expect to you know, see significant and kind of policy memos put out within the next few weeks or month or so. But it really just depends on how quickly things are done behind the scenes.
All right. Thank you so much, Evan.
Thank you,
Sure,
Amrita.
sure.
Hi, Latisha. You're up next. What's your question?
Hi, firstly, thank you for all the information and for the session. My question is like, how likely do you think this is going to be challenged in the court, like the 100 K fees?
Well, we're already hearing that there's preparation for litigation that's taking place. And so I think it's very likely that there will be some litigation on this. You know, when the government raises fees for immigrant petitions, there's a certain process they have to go through. It's called notice and comment rulemaking. So the government puts out a notice saying, hey, we're planning on raising these fees, and then they give people time to respond and provide their input. And then from there, the government responds to those comments, and then they publish the rule ultimately. But with this, you know, this was done in a completely different way. Did we lose you? Are you still?
I'm still here. I'm still here. Yeah,
Okay,
here.
perfect. Okay, so so you know, I don't know exactly what the arguments are that are going to be made, but I imagine they're going to focus on a lot on that these procedures were not put in place. The president's proclamation describes this as being a national security issue, and so, you know, a lot of the argument will be on that, whether there's, you know, there's a strong enough argument to back that up.
Okay. Thank you,
Thank you.
Latisha. So you want to have another scenario question. What if somebody have their H-1B approved, but is in council processing and it's not been effective yet? They travel, attend the interview to get stamping to come back inside. Will they also run into paying this fees?
No, the fact is that the petition was already filed and it was already approved. You know, even in the scenario that it was only filed and not approved yet, the fact that it was filed before September 21st is enough. And so once you demonstrate that, and then you have the H-1B approval, you're fine to travel overseas, get the stamp, and then come back to the US.
Okay. I have another question. I think everybody might want to know the answer to this. as of now, what's the best option for people on OPT and STEM OPT?
Good question. A lot of our advice to people is start looking at other options for your future, whether that's pivoting towards an O1 visa, and these will be, specific to your career and the things that you've done, and even the things that you've planned on doing. So, if somebody is able to file for an EB2 NIW, and that's a national interest waiver case to try to get their green card through that. The challenge with a lot of these is that still there's a wait time, with the fact that the priority dates are not current for all of these visa types. So the O1 can be a very good stepping stone toward an extraordinary ability green card. Now, one thing to be aware of within that classification is the O1 mirrors the EB1A, which they're both extraordinary ability petitions, but one is a temporary non-immigrant visa that's adjudicated quite a bit more, with more leniency than for the green card. And so that one could be a good option to move forward with. There's also J1s, a lot of different options, but what I would suggest is just have a consultation with an immigration attorney and see what your potential options could be.
Okay. Isaiah, you're up next. I can see your question on the Q&A, but you are welcome to speak up and ask your question.
All right, thank you, Raghu, and thank you, Evan, for giving us some insights here.
Sure.
So just kind of pushing back again on the new petition definition, there's a contradiction where it says this rule does not apply for existing H-1B holders. And so that's kind of blatantly said. And so my question is, well, if we're already approved and we're switching employers, does it not apply for us because we're already approved and we're in the US switching employers?
And that's a great question, and really that's a great point that really would be made in the event that that this type of argument was needed to be made for somebody who was changing employers. So are you pulling that language from the proclamation?
Yes, from the White House.
Okay. So the challenge we have in general is that there are a number of things that have been contradictory in this whole discussion. For example, if I can just give you a brief example of this. So initially, one of the reasons why people were so worried about coming back is for those who had a current H-1B visa, is that there was language that said that the government was also going to deny B1 or B2 visas for people who had H-1B, and they were trying to skirt this new rule to come in on that and then change status. But then the government came out and said, no, people who already have H-1B, they can travel, they can come back. And so that leads you to say, well, why did they have that language about the B1 and B2 visas if somebody could always have just come back lawfully on the H-1B? So there are a lot of these things that are really still up in the air and still gray areas. And so really that's what I should have focused on more of saying with the change of status, that is a gray area that we don't know. But you do have a good point that with that language that for people on an H-1B, hopefully that it would allow them to change employers and even change status. But for right now, just with the language that we're seeing, it's this language of renewals and if it's a new petition, it's required to pay the fee. And so we are taking a very conservative interpretation of that, and hopefully that does get fleshed out more. But for right now, this is a very gray area.
Okay. I appreciate that. And just a follow-up, if I can, could you explain how the lawsuits work and how that can actually change some of the implementations here?
Sure. So the Administrative Procedures Act someone can bring a claim where they're stating that the government acted in a way that was arbitrary and capricious and not in accordance with law. And so what would happen is someone files a petition in federal court, and they could go at this with several different arguments, but one of them could be that the agency is disregarding this requirement that they have to do this notice and comment rulemaking to issue new fees, and that it was arbitrary and capricious for the government to just say point blank, we're going to change the fee in an instant, and we're going to give another pretext for why we're doing that. So and then the way litigation happens is the attorneys file a complaint, and then the government has a certain period of time to respond with an answer, and then the whole process begins with a lot of court filings going back and forth and doing a process of discovery where we're trying to gather documentation from the government and things like that. So it's quite a lengthy process, but one of the first steps would be that someone would file, most likely, an injunction trying to have the federal court put a pause on this until the litigation is finalized. It could also be a class action lawsuit where many different people who are affected by this get brought into one lawsuit against the government. Does that make sense?
Yes, sir. Thank you.
Sure.
Thank you, Isaiah. So I have another question. Is there an exception to 100K fees for healthcare professionals?
Well, this is a great question, and this is one that it does appear the government has come out and said that doctors would most likely qualify as having an exemption here. And this also, even if they didn't have a directive like that, this would be an instance that would be a good candidate for this national interest exemption.
Okay.
And so we'll have to wait and see, one, if the government continues to put out more directives about who would be exempt automatically from this in certain positions, and then beyond that, how they are adjudicating the national interest exemptions.
Okay. Hi, Luisa. You're up next. You can unmute yourself to speak up.
Thank you. Can you hear me?
Yeah, sure.
Okay, Pepe. I have heard that there are many categories of H-1B, so I would like to know if for teachers who are under CAP exemption and they are 214
Dot
214.
2H, yeah. So
Yes.
basically cap exempt category and non-profit related.
Yes, they have to pay the fee.
So this is one that the proclamation and the FAQs have not differentiated between the CAP exempt organizations and so there really isn't a guidance on this. So it appears that they would still have to pay the fee, but I imagine this will be one of those instances that the government officials will that are trying to sort this out and provide more guidance on this. They will be most likely trying to determine who would be included, in an exemption, and that might be a good candidate, those types of positions as well. But at this time, we just don't have any guidance on that, so we just have to wait and see. That said, it's just hard to say exactly how the exemptions would come about with the national interest. I imagine that they would put doctors ahead of teachers, but I would hope that they don't have to line up the categories like that. But at this time, I mean, this is one of the major challenges with this, is that just people don't know to what extent it applies. And right now it does appear to apply to all H-1Bs.
Okay.
Oh, thank you. And excuse me, but if, for example, my visa, H-1B visa is already approved, can I travel outside and re-enter again?
Yes, because you already have an approval, you can travel outside the US and you can return.
Perfect. Thank you so much.
Thank you, Luisa. Hi, Deepak. What's your question?
Hey, hi Rahul. Hey Ivan. My question is, I know we talked about extensions. So what about the amendments? If you're changing within the same company to a different role, where the job code is changing, but it's within the same metropolitan city. So will the 100K apply to that? Will it consider as a new petition?
That's a really good question, and I would say that most likely it would not apply to that. Those are when you look at just the term amendment, basically you're updating the USCIS with the petition. So again, this is still part of that gray area, but I think with something like this, it's more likely that the new fee would not apply to that. So that said, I mean that's also, I mean, I have this viewpoint on, immigration law should make sense, and the changes that they make should make sense. And so, if I were adjudicating a case like this or trying to figure out how far this extends, that would be a scenario where, well, I would push back and saying, that one should not be one that should be viewed as a new petition. And especially as you look at what the president's priorities here are with this, what he's trying to do is encourage foreigners to come to the U.S. that are at a higher level of expertise and at a higher wage level in general. And so with that, the viewpoint from the government, the way they're talking about these new petitions, they're really not trying to say everyone who's on a current H-1B right now is just going to lose it. And, it's not like we're starting first with all the H-1B, individuals. So in that scenario, I know that was a very long-winded way to answer that, but I would think that doesn't apply. But again, you'll need to continue to follow the guidance that is coming out. But my sense is that would not be a new petition.
Thank you. Thank you both. Yeah.
Thank you, Deepak. We have another question, Ivan, from Nikhil. How does USCIS process the cases from 21st when there are no clarity on how the rule is being applied?
Well, great question. So when I worked for the government, anytime there were massive changes like this, and granted, I say changes, but I don't remember changes happening like this. But generally speaking, when there were new procedures being put in place, or even new case types, what happens is the USCIS oftentimes puts those on hold for quite a period of time. In other words, like, people are saying, we don't know exactly how to handle this. It's going to wait until we have certain departments that go through things and give us some direction, and then we move forward. And then from there, they start spreading out the petitions to the officers and have them approved. So the training does take some time to train officers on these new things. I guess one example I can give you is from the time where there was the Afghan withdrawal. There were a lot of petitions being filed for humanitarian parole applications. And at that time, the government got so many of those applications that they had to put it on pause for a while and try to figure out how it was that they were going to adjudicate all those. And then there were some lawsuits that came out about that as well. So that's one thing that you have to keep in mind as well, is the government can't just go from deciding petitions one way and then all of a sudden decide, now we're going to do it this way because we have so many more applicants or something. That's why people, try to claim that that's an, action that's arbitrary and capricious.
Okay, all right. Bhargav, you are up next. What's your question?
Hello, thank you. I have a couple of questions. One is, right now I'm on my F1 visa and I'll be graduating next year. Sorry, I missed the earlier part of the meeting. So I'm on my F1 visa right now and be graduating next year. So if I end up working in an OPT, would it be under the new petition? And the second question is, say I start working in an entry-level job, would the like I read this that organizations can't file for H-1B petition if I'm working on an entry-level position. Is that true? Thank you.
Well, there's two parts to your question. The first thing I'll say is that because you don't have an H-1B petition already that's been filed, the new fee would apply in your scenario, unfortunately. The other part of your question seems to go to the later part of the proclamation that basically was a directive for the government to start to go through this rulemaking process where they're going to raise the prevailing wage or the minimum wage that's required for H-1B visas. And that will take some time for the government to be able to do that. So yeah, in essence, the bigger issue that you're going to face is the fact that it looks like the new fee would apply, but let's say hypothetically that the interpretation of this changed and that wasn't an issue. Then the second part of your question is, does that mean, you know, upon moving forward with an H-1B that you would have a higher, your employer would have a higher wage to pay? That will take time, like I was saying, with the rulemaking that would need to go forward. So it just depends on how long that takes, and whether the timeline matches when it would be that you would be applying for this. So I would definitely encourage you to keep monitoring this over the next weeks and months ahead, and hopefully things become more clear. And sometimes the litigation will modify things in such a way that, for example, you know, some litigation might put a pause on the fee of $100,000, but during that process, the government may go through the notice and comment rulemaking and make other changes that almost, you know, I really doubt that they would put something in the proposed rule that talks about a fee of $100,000, because they're going to get a lot of comments that say just that's outrageous, that is so high. So anyway, it'll be hard to project how long that would take, but I would just suggest that you keep monitoring that, but also be exploring other ways that you can move forward, other visa types that you could apply for.
Okay.
Thank you.
Thank you.
Sure.
So Ivan, is it possible, looking at how the tariff has been applied over the past few months, that this 100K could be converted into 25K with a big number and potentially adjusted to 25K? Do you foresee, or is there any talks within the attorney circle that this number could be reduced and maybe applied to all the petitions? Is there something like that?
Well, it's a good question. I haven't heard anything like that. The challenge with something like this is that you have, when you look at the way this came about, there are a lot of details that were put in the president's proclamation, and it's unclear how long they had been working on this. But some of the comments from the president have been along the lines of comparing this to like an NFL football team that says, if you want the top talent on your team, you're going to pay, a signing bonus, right? And so, so some of these things they're interesting from just a policy discussion, because it's one thing to give that explanation, but also recognize, well, not every business functions like the NFL or a team in the NFL, bringing people into the sports world with all the revenue they have. So in essence, it's unclear to know whether there would be any reductions in that amount. But when we go back to this discussion about the notice and comment rulemaking, that knowing that the public are going to comment on that, to me, that would kind of dissuade the government from putting such a high fee in that discussion.
Okay, all right. Another scenario question. I think this is an interesting one. I am on STEM OPT on F1 visa with pending H-1B petition. If I go to my home country for stamping, will my employer have to pay 100K fees? So assuming petition is not yet approved and the person leaves.
Well, the fact that they had a petition pending is enough. So as long as they do get the approval and are able to get the stamp, then they're able to come back and travel, and the employer does not have to pay the fee.
Okay, all right. Hi, Bharat, you are up next. Hey, Bharat, are you able to unmute yourself? Let me invite Abhi in the meantime. Hi, Abhi, are you able to? There you are.
Hi, yes, thank you, Ivan. So my question is about the 60 days grace period when, for example, somebody loses their job, they are on 60 days grace period, and on day 30th, an employer B decides to file an LCA for them. But in the meantime, because of this new law, the employer is not clear whether they should go ahead and file the H-1B petition for this employee or they should wait until there's some clarity. And in the process, the clock is still ticking for the 60 days grace period. So what should be the ideal step moving forward for the employer or the employee in this instance?
Wow, that is a really good question, and a really difficult scenario to be in, because every day that goes by that you're waiting for more guidance, the clock is ticking on that. So in that scenario, really, I mean, my best response to that is to just say to keep monitoring that closely and be in touch with an immigration attorney, because the challenge is, I mean, what it really comes down to is whether a change of employer petition is going to require the new fee. So, hopefully the government would come out and give some clarification that they state when we use the term renewal, we're referring to extensions of status or changes of status, or changes in employer petitions. But at this time, the guidance that we're giving is that most likely the new fee would apply even in those scenarios.
Great, thank you. Thank you for answering that.
Sure. Is there any possibility, Yvonne, the wage level could be adjusted before the next lottery process?
Good question. It really depends on the timing of how long this notice and comment rulemaking would take. I do think it's possible for them to have done that within that period of time, especially because the government has already indicated their priorities with this program. And so most likely they would be encouraging the agency to get right on top of it. And, Trump has brought in someone recently to head the USCIS that is more aligned with his priorities as well. So we'll just have to see how long that takes, but my sense would be yes, it's very likely that would be finalized.
Okay. All right. Another question. H-1B got picked in the last year's lottery, received an RFE and got denied. And this year did not get picked. Let's say I get picked next year. Will I be able to claim an exemption because I had the petition earlier, even though it was not approved? But will that person end up having to pay 100K?
My sense is they would still have to pay the fee because there was some finality in the first one, that there was the denial and then there was the subsequent effort to file again. So again, these are the complexities of immigration law, where people say, I really shouldn't, apply in this scenario, but at the same time, at some point, the officers and those who are developing these policies and clarifying them, at some point they do have to draw the line as to who it applies to and who it doesn't. And so in this scenario, I do think from the the guidance we're seeing now, in the limited information that we have, it would seem that would require a new fee.
Okay. What about the gold card program? Will it affect EB1 and EB2 category?
Good question, and especially this has been on my mind a bit because I adjudicate a lot of these. I adjudicated these for the government, and I help file them for people now. The thing with the extraordinary ability visa is that it is something that Congress developed, and so there's the statutory language there, and there's the regulatory language, and so it changes to dismantle those visa types would need to go through significant legislative processes to do that. So it's hard to say, but the fact is, what people should remember is that it takes a lot of time for Congress to enact a law, and then it takes additional time for the agency to promulgate regulations based upon that law. And so for the president just to announce something that overturns all of that, that's not the way laws are enacted in our country. And so a lot of these things will, I'm sure, be addressed in litigation aspects of things. But with the with something like this new gold card program, oftentimes presidents can give directives that start things being moved for Congress to take action and start legislation. So we'll just have to see how this all plays out. But ultimately, we're a nation of laws and systems of laws that need to be put into place. And so, we'll, as we've seen over the last number of years, there are certain things that can be done by executive action or proclamations and things like that. But still, with immigration law and visas, Congress is the one that writes those laws.
Okay, all right. Aditi, are you able to unmute and ask your question?
Yes, can you hear me?
Yeah, please go on. What's your question?
Hi, I think a part of this was answered earlier, but I just want to check with you. Thank you, and thank you, Raghu, for doing this. My question is that I was on OPT and then unfortunately didn't get selected on the H-1B lottery, so I'm currently pursuing an executive program which allows me to work on CPT. And obviously, it haven't been picked yet, and I'm continuing with the program. But my company's immigration attorney has filed petitions every year. I will be filing one next year, hopefully, if it all goes well. And I'm assuming then your conservative, thinking or process, the fee would still apply to someone like me who would need to change from an F1 to an H-1B at the moment, correct?
Yes, and that's really the part of this gray area that I've kind of mentioned before. It's not entirely clear at this point, but our sense is that you would be required to pay the fee, as this would be viewed as a new petition. But like I said a little bit earlier, hopefully there's some guidance that comes out and clarifies this and actually makes it so that anyone changing status to H-1B would be able to do so without the fee. But my sense is, especially with the priorities the president has given with this overarching change, is that it would require a new fee.
Okay, thank you. Thank you so much.
Thank you, Aditi. I don't want to butcher your name. Snigdha.
Yes, can you hear me?
Yes.
Thank you, Raghu. Thank you, Evan, for doing this. I had a question because the first proclamation was worded almost like an entry ban. I'm a little confused. When they say renewals are exempt, do they mean as long as you don't leave the country? Or say, for example, if somebody's renewal is coming up next year they can travel back to India or their home country to get a stamp and re-enter.
Yeah, so and great point. And this is one of the reasons why we as immigration attorneys were so just up in arms about how to help guide people through this. Is that's how we interpreted it initially, was that people who were overseas would not be able on H-1B, that they would not be able to enter the US. But then the government came out and clarified that and stated no very clearly that anybody who is currently on an H-1B or even had an H-1B that was pending before September 21st, they will be able to travel abroad and come back. And so you shouldn't have any issues traveling overseas. Did that answer your question?
Yes, thank you so much. One small follow-up question from the point of view of an employer. Say, for example, we have somebody in our company who we were going to file an H-1B petition for the first time next year. At which point during the application process, would we have to pay the 100K fee? Is it after they're picked in the lottery so that we know for sure whether it's required?
That's a great question, and most likely that that would be the case, that it would need to be after they picked in the lottery. But at the same time, we don't have even any details about how the fee would be collected, and so yeah, at that point, it's unclear. I apologize. Basically, we'll just have to wait and see how that plays out. But with what is likely to happen with litigation on this, a lot of these details are going to become clear later on. But when they talk about the fee, initially there was concern that it was going to be an annual fee. It was just very difficult to go through the proclamation and to fully understand exactly what the ramifications were, because a lot of the language talks about this being kind of a proclamation that lasts for a year and things like that. So anyway, it is unclear how that would be paid. But where it is a one-time fee, it seems like it would be right at the outset of the new petition being filed and being after finding out that it has been accepted in the lottery. So we'll just have to see how that plays out and how they require the fee to be paid.
Thank you so much. Thank you.
All right, thank you. And there are a lot of questions on the Q&A tab, and pretty much most of the questions we have answered in the webinar starting. We've been doing this for almost an hour now. So if you had joined in between, and if I'm dismissing your question, which means please go and watch the replay. The replay is available in 3 different places: the F1 Visa Facebook group, the Happy Schools YouTube channel, and the Manifest Law YouTube channel as well. So you'll be able to watch the replay and get an understanding of what we described at the beginning of the webinar. Also, anybody interested in getting consulting with Manifest Law, please look at the link I posted on the chat. You'll be able to get a discounted rate because you're referring coming from Happy Schools. All right. So Bharat, what's your question, Bharat?
Hi. Thank you very much for thank you, Raghu, and thank you, Evan, for giving us the info. So my question is, so my extension is already approved in June, and my wife is currently in India and waiting for her appointment. She's on H4 basically. So does this affect H4 in any way during the consulate visa appointment or even coming back?
We have not seen any information to give concern to her about being able to enter on an H4, and our sense would be, just because things might change down the road, I would encourage her to come to the US as soon as she can on this, but there should not be any reason why there would be issues. So one of the responses I had given to someone else who, and not in this webinar, but at another time, is basically I stated it this way: the fact that you having the H-1B allows you to travel and enter without the fee. It makes sense to also allow the dependent to that H-1B, the person, your spouse on H-4, to be able to enter the US without having to pay the fee. So in essence, she would be able to travel here without the fee applying. I would just encourage her to, if possible, try to come as soon as possible. Does that make sense?
Yes, thank you. And I have one more question. So there is a possibility of layoffs in my company, and I might have to change jobs. So would that be a new application in a new company? Like, would the 100K apply? Basically, it's kind of a transfer. Yes.
Yes, and this is still a gray area that we're hoping there's more guidance on in the future, but it appears that a situation like that would be a new petition that requires the fee. And so, and in essence, that's another reason to encourage your wife to come in as soon as possible, so that that she's not kept out of the country in the event that you have to, obtain new employment. And if the fee applies to you, that could restrict her ability to come in. I say that, but now I want to take that back for a moment, because well, it just depends. But that's why I say the cautious thing is for her to enter as soon as possible, because she has the H-4. It's unclear to what extent the details might come out about your change in employment, but the best scenario would be for her to come over as soon as possible, so that she's here in the US before you have that any change to your employment. Does that make sense?
Yes. Yep. Thank you.
Thank you, Bharat. Hey, Karthik, what's your question?
Hey, thank you both for the session. My question is, someone on the last year on H-1B and I-140 not yet approved, perm is underway right now. If there is an opportunity to temporarily work from a third country, which is other than US and the home country, and the reason is purely technical career growth, and it's only for 6 to 9 months, is it okay to take on that opportunity right now, or should we be concerned because of all these sudden changes that's happening in the H-1B spectrum?
Yes, I would be concerned by that, because you don't want to do anything that would jeopardize your H-1B. And if you can continue to extend your H-1B, that puts you in the best position. What is your priority date for the I-140?
No, the I-140 is not yet approved. The
Oh, it's not
perm
yet.
process is
I
underway.
apologize. Yeah, okay. Yeah, so in essence, my view would be to basically avoid something like that, so that you can just ensure that you're not having any issues with the H-1B, and that you can continue extending it. Yeah, especially because you need to stay in status during this entire time that your H-1 that your I-140 is pending. Did I answer that, or do you have other questions?
Sure, I understood that it is better to be inside the country right now. Thank you very much.
Thank you, Karthik. Hi, Vinod. What's your question? I saw you had a question about green card filing as well.
Hi, thanks for giving me the opportunity to talk with Aman, and thanks for the help, Raghu. And here's my question. I'm on STEM OPT and I was on lottery recently, but random that was not picked up in the recent lottery. And my employer is ready to file for my EB2. So how long it might take? Does it impact anything on my STEM OPT or my F1 status?
What's your country of birth, Vinod?
India.
Okay.
Okay, and so you're asking how long it would take to have an EB2 NIW approved?
Yes, exactly.
Okay, so if you file that with premium processing, the government will approve that within 45 days, or if they issue a request for evidence, that basically starts the clock over, and so then there would be an additional 45 days. And depending on how long it takes you to prepare to file the application, you're looking at probably between a 3 to 4 month period of time, or maybe up to 6 months, depending on how long it takes to get the petition filed. But then the challenge is, so after, when that's approved, you'll have a priority date, unless you already had an I-140 approved. Did you have an I-140 approved before?
Not it. So I'm planning to do it. I'm planning to start the process. Is it gonna get any impacted for right now scenario, or can I start it like probably by next week? Is there anything concernable that I need to notice up, or
Well, so the challenge you're going to run up against is that every month the State Department puts out a visa bulletin, and that tells you how long you have to wait before you can apply for your green card in certain categories. And so for people from India in the EB2 category, it's still a very long wait time. They're approving cases that were filed before April of 2013. Let me
I
just
think
make
it's
sure.
2014. 2014 was the filing date, I believe.
2014. Okay.
but there is no changes in any any kind of changes in the law for the EV2, right? So I can apply it for right now case, right? It's not like as an H-1B, like it's like 100,000 up and like that. It's just like a regular fee and I can apply, correct?
So perhaps I'm not understanding the question well enough, but it sounds like you're asking if anything has changed in the EB2 category.
Yes. So I want to start up the process and if there is any changes for recent EB2.
No, there's really no changes that have been made to the EB2 program. And we'll need to keep monitoring things with these other discussions that President Trump is putting out about his, proposals to make some changes to both EB1 and EB2 type of classifications. But right now, there haven't been any details given on those. In these case types of classifications are ones that have been in place for many years that Congress has put into law. And so, a lot of work would need to go into having these laws modified, and that would take quite a bit of time. So yeah, I would recommend having a consultation with an attorney to try to find what your options are. Oftentimes EB2 NIWs can also be stepping stones toward O1 visas, and vice versa. Sometimes people with O1s can move towards filing either an EB2 NIW or an EB1A. So the O1 extraordinary ability visas, the O1 is a temporary visa. They're generally more lenient in approving those. The government takes a more strict view of the EB1As, but the framework is the same for both. But like I said, oftentimes the O1 is a stepping stone toward that.
Right. Thanks, Ivan. I think Raghu posted the link. I'll reach out to you. I'll the consultation process. Thanks, Raghu. Thanks, Ivan.
Thank you, Vinod. And to also understand, Vinod, since I believe you are an OPT, right, currently?
I'm in the STEM OPT, correct.
Okay, so if you are in STEM OPT and applying for EB2, the EB2 NIW will not give you work authorization. You still would need an underlying STEM or CPT through day one, or even an O1. So if you have the qualification to be an EB2 NIW, you might reach out to Manifest Law to evaluate to see if you qualify for O1. So from STEM OPT to O1, that will allow you to continue to work after your OPT expires and you don't need H-1B. Then, so O1 is like kind of a parallel track for H1, similar to that, Ivan? We can say that gives you work authorization.
Yeah, it's probably difficult to call it a parallel track, but it's one that that gives you much more flexibility than the H-1B. Granted, the O1 does have a number of aspects of it that probably I would imagine would cause people to not consider it because of some of the language it says you have to show that you have sustained national or international acclaim. Well, you have to meet 3 out of 10 criteria that goes toward that acclaim. And so some of those can be you show that you have a high salary compared to others in your field. If you have publications in your industry that shows that you're recognized as an expert in your field and things like that. Those go towards showing what you need to for an O1. So I think it's definitely something that a lot of people are going to be considering now that there is this issue with H-1Bs. But it would be a good idea to just have a consultation with an attorney and kind of explore all of your background, all of the different options to move forward.
Yeah, so think about that, Vinod, and please you can schedule a consulting call with Manifest Law or attorney of your choice, depending on your specific scenario. Okay.
That sounds good. Thanks, Raghu. Thanks a lot.
All right. Question.
Hi, Raghu.
Sagar and Nisar, those will be the last 2 questions we will do here, and then we will wrap up this meeting.
Yeah, hi, Raghu. So I'm an Indian citizen living in Canada on a Canadian PR, and I travel or commute to Detroit from Windsor to Detroit. So it's a everyday commute from morning and again, I come back in the evening to home. So as per my knowledge, and also sometimes I work from home in Canada, and also I commute. So how does it's gonna affect my my status, because I already have a H-1B on my hand in my passport, and my renewal is going to be up there in January 2026. So what are my challenges? So I'm still confused about this.
Okay, well, in your scenario, what you would need to do is just renew the H-1B, and by doing so, you would not be subject to the $100,000 fee, and that would enable you to stay in H-1B status and continue to come back and forth.
So it doesn't affect my renewal at all.
No, so the government has made it very clear that renewals will not be ones that trigger the $100,000 fee. And so what is unclear is whether renewals allow for people to change employers and change from visa types. But what is clear is that someone who has the same employer and is just essentially extending their H-1B, the $100,000 fee is not going to apply to them.
So, for example, if I have to change my employer maybe next year or somewhere around maybe next year, so so what if that could impact, because as being in Canadian PR and still commute to Detroit, so how does that would affect me?
Well, and that's why I would suggest you'll need to continue monitoring the interpretations that come down. But for what we're seeing right now, you changing to a different employer would mean that it would be a new petition that requires the new or the $100,000 fee. And so, yes, I would just suggest that you monitor closely what happens if there is litigation that takes place, as well as what the continuing guidance is that kind of unfolds from here.
Okay, so it only applies for the new employers, even if I have the H-1B, right? Okay, so I have to stay with.
Yeah, if you stay with the same employer, then you don't have to worry about the $100,000 fee in extending it.
Thank you, Sagar.
Okay, thank you. Thank you.
Sure.
And for the listeners, we are planning to do an O1 visa webinar along with an EB1 webinar. The details will be posted. We are supposed to do it this coming Friday, but since we've been doing this H-1B news webinar, we thought we will push that webinar by another week or so. So watch out for the notifications about Specifically, how do you meet the 3 out of 10 criteria that Ivan was talking about? So that webinar is coming up shortly. And then we'll be doing a few more webinars as well with Manifest Law. As you can see here, they've been a great partner for Happy Schools. We are bringing this Q&A session to clarify your questions. So Nisarg, yours will be the last question through the microphone.
Hi. Thank you, Raghu and Ivan. I think you have answered my question that extension doesn't apply to the 100,000 fees. But I have a different question. Basically, my wife, she was in H4 right now, and she has an approved H-1B consular petition, basically. That is, we have not activated that H-1B yet. So if a different employer can use that petition to activate H-1B, and if she goes for stamping, is there any issues, do you think?
It's a good question. So tell me more about the different employer aspect of this.
Right. So basically, she has worked on H4 so far, and she didn't wanted to change the status to H1, right? So while she was on H4, the employer filed her H1B, and we have a consular petition approved. We didn't activated the H1B, and we thought at that time okay, it's not need as of now, right? But now I feel the circumstances are there. Is there a possibility that a new employer, a new different company transfer this petition, consular petition, and she goes for stamping and comebacks? So just wanted to see your thoughts.
Yeah, this is a great question, and it is one that is quite complex here. But so let me take this kind of a dual approach in answering this. So, for example, the employer who filed the change of status petition in which the H-1B was approved, even though the visa stamping hadn't happened, if she's intending to come back and work for that employee, the fee would not apply. That basically is the scenario where the petition was filed before September 21st. It was approved, and so she's able to come in. But whether it's if a different employer is using that, and this is an interesting scenario. So what the wording in that the government is using is the word petition, right? And so she's already filed a change of status petition and had that approved. And so I think there's a good likelihood that she wouldn't be caught in the crosshairs of having to pay that $100,000 fee. But this is really a complex issue in terms of whether she's if she's not intending to come back to work for that employer, this would essentially be a change of employer type scenario. So in other words, with this one, I apologize, but I would suggest that you have a consultation with an attorney on that, but I would also give it some time to see if some additional guidance comes out first. Now, am I understanding this correctly in that she's just trying, she's not intending to work for the employer who filed the change of status, is that right?
No, like employer didn't file the change of status. She remained on H4 EAD throughout the whole period, right? So we haven't approved a petition from the employer. Now she has already changed the employer. She is on H4 EAD, right? And let's say that petition is consular approved, right? That H-1B was never activated, but the validity
So
is
Ivan,
still
so I
active.
think let me can the employer who filed the initial petition is not there in the picture anymore, but they have the approved H-1B. Assuming it is not revoked, can another brand new employer come and do a change of status from H4 to H1, or will that be consular processing? That's probably the summary of the question.
Or can we do it inside USA? Yes.
Okay, yeah, my apologies if I misunderstood this. So this would be viewed most likely as a new petition, in that it is where she's on H4 now and is doing in both of these, our guide, the recommendation or the interpretation we're providing is that both for people who are changing status from one status to another status, or for those who are changing from one employer, H-1B employer, to another one, that would constitute a new petition and require the fee.
Okay.
So does it fit within that? Is that this scenario, or am I still missing something?
I think you answered the question.
Yes.
Yeah, got it. Thank you.
Right.
Thank you,
Okay.
Nasar.
All right.
All right. So 2 quick questions before we wrap this up. Can somebody go from F1 to O1, then to EB1?
Yes. So the way they would do that, and you could actually have an EB1 case and an O1 case filed at the same time. But most times what I would recommend is that you use them as a stepping stone, as I'm indicating, because the O1 will be valid for 3 years. And you can also continue to build up your acclaim, your recognition in the industry over that period of time that you have the O1, and that puts you in a better position to have the EB1 approved. But yes, F1s, and I will say this, the government has made some positive strides toward extraordinary ability visas, where in the past, when I worked for the government, oftentimes the officers would take the viewpoint of people earlier on in their career don't likely qualify for the O1 and the EB1A. But there's some guidance now from USCIS that says, no, people early on in their career, they can still establish this if they meet the criteria.
Okay.
And so I would suggest just having a consult with an attorney and
Sure.
discuss where you are in the process.
Okay, last question. Can somebody go from OPT to J1?
So yeah, people can transfer from any visa classification to another type. As long as it hasn't expired, they can go to a J1. So that would be another one that I imagine a lot of people will be looking into. And I would suggest having a conversation with an attorney about that as well. But
Okay.
with any change of status, the most important thing is that the change has to happen before the expiration date.
Okay, all right, fantastic. And right now I'm sharing the screen of where you can schedule a consulting call with Manifest Law. Please make a note of this, and you'll be able to reach out to attorney Ivan Law or Nicole or anybody attorney from their team. And we also plan to do another webinar to specifically talk about how the O1 works, the eligibility criteria, and how do you transition from O1 into EB1 option. And for those who do not have understanding between O1 and EB1, the EB1 is for green card category. And the O1 will allow you to maintain your status to work in the US. Like how you have OPT that allows you to work, how you'll have H-1B that allows you to work. So you cannot work just with an EB1 petition. You would probably need an underlying OPT or H1 or O1. So we will touch upon that in the next webinar. Thank you, Ivan. Thanks for, we spent close to 1 hour and 40 minutes. Fantastic. We probably will do another session depending on how the latest H-1B news develops. So please follow Manifest Law on YouTube channel, on their Instagram page. Also the replays that we have done. This is the second webinar that we have done. The previous webinar was about what if you got laid off on H-1B? What are the alternatives? So that webinar is also available on the Happy Schools YouTube page and as well as the Facebook group. Ivan, thank you and appreciate you spending time with us answering the questions.
Sure. Likewise, it was a pleasure, and I hope you have a good evening.
You too. Take care. Thank you, everyone. Bye-bye.